Hi students, today we're starting our sort of mini unit on legal interpretation. We're going to look at a case to start off, an old case again, Church of the Holy Trinity versus the United States. We've got a picture here of the church that was involved in this case. Apparently, I was just reading that it was torn down, sold and torn down not too long after this case, a few years maybe after the case was over, but it looks like a pretty impressive building. Alright, so the reason we're looking at this case is because it's going to be an important one for Justice Scalia when he's articulating later on, next week, his views about how we should interpret the law. He's going to point to this case. So we want to sort of know what this case is about and sort of the main kinds of arguments made so that when we're looking at Justice Scalia's judicial philosophy, we can sort of understand what he's talking about and the kinds of arguments he's making. Okay, so the facts of the case, pretty simple. So the Church of the Holy Trinity hired this guy, E. Walpole Warren, a foreigner who was living in England, to be its pastor. I've even got a picture of this guy here. So that's a picture of E. Walpole Warren. But the problem with this is that there was an act passed, the Alien Contract Labor Law, that prohibited U.S. corporations from encouraging foreigners to migrate to the U.S. by hiring them to perform labor or service. So, immigration is not just a controversial topic today, it was a controversial topic back then, and there was a time at which the U.S. passed this law that was going to prohibit corporations from, promising to pay people to migrate to the U.S. to offer them a job before they had come to the U.S., things like that. And so the question here is whether or not the Church of the Holy Trinity violated the Alien Contract Labor Law. So, as I just said, the central legal question, right? Not the philosophical question, but a legal question. Was the Church of the Holy Trinity guilty of violating this Alien Contract Labor Law? Now, on the face, you might think, yeah, they hired a foreigner to work at the church, encouraging that person to migrate to the U.S. That seems like exactly what the law prohibits. So I'm just going to read to you the sort of text, the relevant text of the labor law. So, be it enacted by the Senate and House of Representatives of the U.S. of America and Congress assembled, that from and after the passage of this act it shall be unlawful for any person, company, partnership, or corporation in any manner whatsoever to prepay the transportation or in any way assist or encourage the importation or migration of any alien or aliens, any foreigner or foreigners, into the U.S., its territories, or the District of Columbia, under contract or agreement, parole or special, express or implied, made previous to the importation or migration of such alien or aliens, foreigner or foreigners, to perform labor or service of any kind in the U.S., its territories, or the District of Columbia. So again, we read that and we might think, yep, Church of the Holy Trinity, it looks like they violated the law here. What do you think? Did the Church of the Holy Trinity violate the Alien Contract Labor Law by hiring E. Walpole Warren as its pastor while he was still living in England? Now, you might think, John, you've just told me that it looks pretty clear, and I have said that. But what if I told you that the reason that Alien Contract Labor Law was passed wasn't to prohibit people like pastors from coming into the U.S.? It was rather passed to prohibit unskilled laborers from entering into the U.S. Again, the focus here is along the southern border where railroad companies were hiring laborers from Mexico to work on the railroad. If I told you that was sort of why the law was passed, does that change your judgment about whether or not the Church of the Holy Trinity violated the law. So anyway, it's worth thinking about that, what you think, right? And hopefully maybe you've read the case already before watching this video, and if not, maybe you want to do that now. It's good to think about, well, what do I think the answer is? How did the court rule here? Think about that question, then when you're ready, pause if you want to. Think about that question. When you're ready, go on to the next slide. All right, so Justice Brewer's majority opinion is the opinion that we get. We don't get a dissenting opinion in this article. Now, Justice Brewer is going to start, as you'll see justices often do, by considering sort of an opposing argument, and then he's going to turn to his argument. So he starts by acknowledging the church did, as a matter of fact, encourage Warren to migrate to the U.S. by hiring him to perform labor or service. Moreover, Justice Brewer says the alien contract labor law explicitly made exceptions for some people, like professional actors, artists, lecturers, singers, and domestic servants, but didn't make an exception for pastors. So the alien contract labor law says, well, you can't hire laborers unless they're this kind: actors, artists, lecturers, singers, domestic servants, etc. But it didn't make any exceptions for pastors. And you might think, well, then pastors aren't an exception. Pastors count here. But, and now Justice Brewer is going to sort of transition to the kind of argument that he wants to make, the conclusion that he thinks is right. So we get this quote. He says, "It's a familiar rule that a thing may be within the letter of the statute and yet not within the statute, because it's not within its spirit, nor within the intention of its makers. This has been often asserted, and the reports are full of cases illustrating its application." So what he's saying here is that it might be something that the rule appears to say, but it really wasn't what the people who wrote the statute intended to be the case, and so that's going to be his main argument. Okay, so as we transition to Justice Brewer's own view, he says Congress never intended the statute to prohibit corporations from encouraging skilled laborers to migrate to the U.S. So here he's making a distinction between unskilled and skilled laborers. He's saying what this statute was meant to prohibit was unskilled laborers from coming in, or corporations from encouraging unskilled laborers to move to the U.S., but it wasn't meant to prohibit corporations from encouraging skilled laborers to migrate to the U.S. Okay, so as evidence, he notes a number of things. So first, he says, here's the title of the act. The act is titled this: "An act to prohibit the importation and migration of foreigners and aliens under contract or agreement to perform labor in the U.S., its territories, and the District of Columbia." So note that the emphasis there is on labor. And Justice Brewer says, the common understanding of the terms labor and laborers does not include preaching and preachers. So he's sort of pointing out that when we look at the title, the labor and service that appears in the act isn't really there, and the focus is on laborers. And when we think of preaching and preachers, we don't think of laborers. More evidence. The law was written to prevent railroad companies from attracting foreign workers by promising to pay for their relocation to the U.S. So again, he is appealing to here's the reason why they wrote that law. And we're aware that that's the reason, we know that this is why they did that. And so if it's really about the railroad stuff, maybe it's not really supposed to apply to churches hiring pastors from Europe. Another reason that Justice Brewer gives is saying there's no suggestion that the U.S. had a surplus of quote-unquote brain toilers, or that the influx of foreign pastors was depressing wages. So again, the law that was passed was about, keeping wages high. If we allow people, migrants in, they're going to depress the wages, the cost of labor goes down, people either lose their jobs or they still have jobs, but they don't get paid as much. And so there's no sort of reason to think, oh man, all these pastors coming in from Europe are really depressing the wages of pastors. Um, Finally, legislators had considered modifying the statute to refer only to manual labor and manual service, but they decided against it in the interest of time and on the assumption that it would be so construed. So they actually looked at the legislative record here, and they said like, hey, look, they have some notes about like why they were passing this law. And there was even this discussion about should we modify the statute to include the word manual labor and manual service. But they said, let's not worry about that. We might as well just pass it now. It's going to take longer if we have to make this edit. And we assume that when the justices are evaluating this, they're going to know that we meant manual labor and manual service. Sorry, I said the last point was the last one, but this is the actual last one. Congress people wouldn't have voted for a law that nullified contracts like Warren's. So if we think about would lawmakers have passed this law if they thought it was going to prevent churches, synagogues, etc., from hiring pastors, rabbis, etc., from overseas? And he thinks, no, that's not the case. So he has this quote to sort of suggest this. And I like this, right? So in philosophy, we're going to be using thought experiments and examples in these sort of creative ways. And I think this is a nice instance of a thought experiment. He says, suppose in the Congress that passed this act, some member had offered a bill which in terms declared that if any Roman Catholic church in this country should contract with Cardinal Manning to come to the country and enter into its service as pastor and priest, or any Episcopal church should enter into a contract with Canon Farrer, or any Baptist church should make similar arrangements with Reverend Mr. Spurgeon, or any Jewish synagogue with some eminent rabbi, such contract should be adjudged unlawful and void, and the church making it be subject to prosecution and punishment. Okay, that was like a long sentence, right? So we got to sort of parse through that. Then you say, imagine that someone in Congress had suggested a law that would prohibit churches, synagogues from hiring these kinds of people. Can it be believed that it would have received a minute of approving thought or a single vote? So his point is that if somebody had tried to pass a law like this that would have prevented pastors from being hired from overseas, would Congress people have voted for that? And he says it wouldn't even received a single vote. I think that's like a pretty interesting example. I also wonder, like, are these people that he's referring to like actual, people, pastors in the area? Like maybe Cardinal Manning is like, maybe he's like a real cardinal that people like wanted to come to New York or something, or Canon Farrar, Reverend Mr. Spurgeon. Maybe these people even were hired from overseas. I don't know. I think like the example is really fascinating. I think it's interesting to think about what exactly he might be referring to here. And it's more powerful, right, if he is referring to actual people. But anyway, the point is the same. So if we're going to put Justice Brewer's argument into standard form, we might put it like this. So a law's content depends on the intentions of its makers. Premise 2 says that lawmakers did not intend for the law to prohibit religious institutions from encouraging skilled laborers to migrate to the U.S. So then we get premise 3. Right? It says if premise 1 and premise 2 are true, that is, if a law's content depends on the intentions, and the lawmakers didn't intend for the law to prohibit religious institutions from doing this thing, then the law doesn't prohibit the Church of the Holy Trinity from hiring Warren. If all those premises are true, premises 1, 2, and 3, it follows that the law doesn't prohibit Church of the Holy Trinity from hiring Warren. So that argument's valid. We want to look back, say we think, no, really it does prohibit Church of the Holy Trinity. We would need to figure out which of these premises we're going to deny. And I think if we're going to pick, right, premise 1, a law's content depends on the intentions of its makers. That's sounds kind of controversial. Premise 2, lawmakers didn't intend for the law to prohibit religious institutions from encouraging skilled laborers to migrate to the U.S. That seems pretty plausible. He's given us some evidence for that, right? He gave us that thought experiment. Would people have voted for a law if it had done this? So I think premise 2 is true. And I think if the law's content depends on the intentions and the lawmakers didn't intend, then yeah, the law doesn't prohibit the Church of the Holy Trinity from doing this thing. So all that is to say that I think premise 2 is true, premise 3 looks true. The controversial premise is going to be premise 1 up there. So the content depends on the intentions of the makers. That's going to be the controversial premise. That's going to be the premise that Justice Scalia is skeptical of when we come back to this later on. And it's worth noting, right, that this does play into the debate between legal positivists and natural law theorists. The positivist, someone like Scalia, is going to say there's something a little bit suspicious and problematic about making the law depend on people's intentions. It seems like maybe morality is going to, our moral views are going to start creeping into how we interpret the law, and he thinks that that's a problem. Anyway, we've seen arguments like this before in the Riggs versus Palmer kind of case. We're seeing an argument like this again. This claim that the content depends on the intentions is a controversial one, and we'll talk more about it later. Okay, so for next time, I'd like you to read Smith versus the U.S., another case, much more recent though. Again, it's going to raise issues that are relevant to debates over judicial interpretation, legal interpretation. And after you read that, complete the reading quiz. All right, see you next time.